Hi there, you're watching BloombergQuint, and this is the fine print. In a big move, the government has decided to deal with the infamous retrospective amendment of 2012. 17 cases, including the headline ones, Vodafone and Kane, will benefit from this move, which were hit by demands on account of this retrospective tax. The government tabled the Taxation Law Amendment Bill 2021 in the Lok Sabha today, and this is what it says. No tax demand will be raised on the basis of 2012 retrospective amendment on indirect transfer of Indian assets. For this benefit to be effective, the transaction should have taken place before 28th May 2012, and this amendment will only apply prospectively. Now, for pending cases where businesses or companies are litigating this demand against the government, they will get the benefit of this move only if they fulfill certain conditions, and those are withdrawal or furnishing of an undertaking for withdrawal of pending litigation, and furnishing of an undertaking to the effect that no claim for costs, damages, or interest will be filed against the government of India. Now, this is, of course, to sort of curtail the damages that the government of India could potentially sort of have to pay up if Vodafone and Kane kind of arbitration proceedings don't go its way. But let me come to now Ajay Rotti of Dhruva Advisors to take us through the fine print of this amendment and what it really means. Ajay, welcome to the fine print. This caught all of us by surprise. None of us were sort of expecting this to come in, right?
Yes, a pleasant surprise.
Yeah. So, Ajay, let me sort of come straight to what the amendment is seeking to do. The government has not withdrawn the 2012 retrospective amendment, which the then finance minister said it's only clarificatory in nature. Before we go to the fine print of this bill, do you want to quickly help our viewers refresh their memory that what exactly the 2012 amendment said?
Sure. So, the crux of the issue here is really what's often called the indirect transfer, which is you transfer shares of an Indian company by not really transferring the Indian company, but transferring a company which is one tier above that Indian company, one or many tiers. And then you actually take the law at that point did not tax transfer of shares of foreign companies. And therefore, you could transfer shares of a Singapore company, a Mauritius company, etc., which effectively held the Indian company. And so you're economically transferring the Indian company, but you're transferring shares outside, and therefore it was not taxable. So what the retrospective amendment did was to actually state and clarify that when you're transferring shares of a foreign company, which derives its value substantially from Indian assets, then that company share will be treated as an Indian share, which means you would be liable to tax in India. Therefore, if any foreign shareholder transferred share in another company, which is located in a country other than India, but that company had subsidiaries in India, then you would pay tax. And I'm sort of oversimplifying it, and which the indirect transfer of Indian assets would then become taxable in India. Now, when they introduced this in 2012, they actually made it retrospective from 1962. And therefore, whichever transfer, whenever it would have been done before that, would become liable to tax after 2012. And there were, while Vodafone and Kane are two of the most prominent cases, there were many other cases where the government had demanded taxes for a transfer which had happened much before in time and retrospectively levied tax on that. That's really the crux of the issue here.
Sure. Like they've mentioned in their statement of objects and reasons, Ajay, that there are 17 such cases where demand was raised basis this 2012 amendment. Help me understand, Ajay, what is the situation in terms of cases where, let's say, the entities like Vodafone and Kane have won arbitration awards against the government? Let's talk about those set of cases first, because this development has just come in. Kane and Vodafone have not sort of are yet to sort of indicate what they plan to do. But let's assess both situations where Kane and Vodafone agree to drop the enforcement proceedings against the government of India. And if they don't, then what happens?
Sure. So where, these cases are in different cases would be at different levels of, the whole appeal. You have multiple stages of appeal going right up to the Supreme Court. Kane and Vodafone had actually taken an alternate dispute resolution mechanism, which is to invoke arbitration against the government of India, using investment agreements that were there. And therefore, they were not in the traditional litigation route provided under the Income Tax Act, but they were under arbitration proceeding. And both of them, as of recent past, had won awards in their favor, and the Indian government had challenged those. So that's where we are today on those two large cases. Other cases are at different stages of appeal, etc. But those meant nothing because the law was very clear, and therefore those demands stayed. And some of them have paid taxes, including Vodafone and Kane. There are certain amount of taxes that they've already paid. And the arbitration award, and this is important, Payaswini, had actually awarded not just the refund of the taxes which were paid, but also interest and costs that Vodafone and Kane had incurred in arbitration. So they had actually won the principal amount plus interest plus costs.
Okay, so we'll come to the other cases which are in the litigation pipeline in India, but specifically on Vodafone and Kane, like you mentioned, they won the principal, they won sort of costs, and they won the interest amount. What this bill seems to be proposing is that, look, if you decide to drop this arbitral proceedings against the government, what we will pay you is just the principal, right? Does it sound like a sort of lucrative enough proposal for, let's say, if Vodafone or Kane comes to you for advice today, does it sound like a sort of lucrative proposal for them?
I think it is. And let me just take a step back, explain what this bill is actually proposing. And there are two large parts to this bill. One is the bill clarifies that you can't raise any further demand retrospectively. And they put the date as 28th May, which is the right date because that's the day the bill which amended this retrospectively got passed. And therefore, it's in true spirit a zero retrospective amendment. So any transactions which have happened before 28th May, you cannot raise any further demand today. That's one part of it. Second, they say if there is a demand already raised and the dispute is at different levels, the bill says that if you satisfy certain conditions, then that order will be deemed to have never been passed. And those conditions include what you are stating, which is to withdraw these appeals and claims and arbitrations, etc. Therefore, yes, Vodafone and Kane will stand to lose the awards, the costs that have been awarded. There is no interest because the bill provides that if there's a refund due, only the refund will be issued and no interest will be paid. It may not sound as lucrative in that sense, but the fact is they are able to, obtain a closure for this, which is really what even somebody like Crane has been stating, that their preferred option has been to, settle and find a middle path rather than litigate this forever.
Okay, all right. So, we'll see in the coming days what, in terms of their positions, what Kane and Vodafone decide to do. If they don't, then I suppose the litigation or the government stand sort of itself stands. But do you believe that now that the government has made this move, will it anyway, let's say Vodafone and Kane decide not to sort of drop the arbitration proceedings, will the government stand now sort of weaken its case before the arbitral tribunal appeals that the government of India is pursuing in both these cases?
I really don't think so because from the word go, this has always been a retrospective amendment. Okay. It's not been an amendment which has been prospective. So that's a hurdle that India has always had to cross to justify why there's been a retrospective amendment. Today, this opens up an avenue for them to say that they've walked the path, middle of the path to say that we've offered this. Whereas somebody has not withdrawn. I think it's too early, but I'll be surprised if people don't withdraw their litigation and take this and settle the matters and close these disputes. Because
all right, okay, sure, please go ahead.
India could have very well, the government today could have just completely taken out these provisions and not made it retrospective. I think by putting these conditions, what they have ensured is that people who want to litigate can do that. If they are interested, but where they withdraw, then there is a settlement and it's not a blanket settlement for everybody.
Yeah. So, okay, let's talk about the cases which are in the litigation pipeline in India. So those sort of cases, once I'm guessing they will provide the process on how do you apply for a withdrawal of this nature. So those get automatically dropped. And in those cases also, wherever any money has been recovered from those assessees, those refunds will be issued, of course, minus any costs and interest.
Correct. That's right. if they're in appeal, whether at a high court, Supreme Court, wherever today, if they withdraw those appeals and the provisions say that once that is done, they'll be eligible for a refund if they've paid any money, but without interest.
Okay, so very quickly, why not just remove this contentious amendment? Why let it continue on the statute books, Ajay?
So, if they removed this amendment completely, they could have done that. But what happens is all the ones which are today under litigation, then they just get withdrawn without any conditions. The orders just go away, they just fall away. What they are essentially trying to do today is also sort of protect the interest, to say that there'll be no further cost, there'll be no interest cost to the government. Therefore, there's a conditional withdrawal to state that if you withdraw all your appeals, you withdraw your other claims, only then will this fall away, and therefore there'll be a refund due. I think it's to that extent it's slightly different from just taking out the provision altogether from the statute.
Okay, Ajay, I mean, the timing of it is sort of very opportune for Vodafone Idea, right? Because there is severe financial stress that the company is facing, which, for our viewers, you can go on BloombergQuint.com. We've been reporting extensively on it through this week. It certainly comes at a very opportune time particularly for Vodafone.
I would agree, and it's no secret that these two litigation particularly have impacted foreign investment, the way foreign investors look at India, etc. And this is something that even our earlier Finance Minister Arun Jaitley had acknowledged, and he'd actually stated that we will not do any of these retrospective amendments anymore, and acknowledged on the floor of the House that these have impacted the investments into India. And if I remember right, Vodafone also at some point had said that to commit further into the subsidiary and business in India, they would want the tax dispute to get settled. So I think it is an opportune time, and Vodafone can now definitely look at investing further in India, etc., with this being put to bed.
Sure. Last question, Ajay. Was there anything else in the fine print that you thought in terms of process our viewers should know at this point? Because we've talked about, the amounts that have been collected being granted as refunds as long as, those undertakings and those conditions are fulfilled. Anything else that you thought was key here?
No, I don't think so. And I think one important thing outside of existing litigation also is that this very clearly states that no new orders will also be passed retrospectively under this provision. Not just the ones which have already been passed. There'll be no further orders passed in new cases after this change. So even those where there was a possibility, even those go away.
And like we discussed, that it's not like indirect transfers of the nature that we are talking about won't continue to be taxed. The amendment is very much there on the statute books. But now the investor community knows that, these are the tax consequences if any indirect transfers where assets are situated in India are being, transacted abroad. So those transactions continue to be subject to the provisions of the income tax law.
That's right. All those transfers after 28th of May 2012, which is when the finance bill of that year got the presidential assent. After that, all transfers which happen, if there is an indirect transfer and there is a tax liability in India, those would be liable to tax.
All right. Okay. I guess besides the immediate financial impact for this in his address had said that while the government will not bring in fresh cases, there was no really resolution of the earlier cases that were, being seen as a negative sentiment coming out from India. So I'm guessing clearly a positive message on that end.
Yeah, absolutely. And I think it's a very positive message because you've now really cleaned up all the past issues which have been there. And, they could have chosen not to appeal against the Vodafone or the Kane, awards, in which case then the relief would have been restricted to those two, not all the other orders. What they have done today is actually better than that, because all cases which are open, whether litigated or not, whether in arbitration or not, today get this relief. I think it is a very, very welcome change, and this is big.
All right. Thank you, Ajay, for giving us or sharing your quick insights on what this bill means for the investor community, the 17 pending cases, and the sentiment that goes out to the investor community. Like we said in the beginning, this bill has just been tabled in the Lok Sabha today, and hopefully it will get Parliament approval soon. Thank you for joining us here on BloombergQuint, and thanks, Ajay, for joining us.
Thank you.